On 7/22/24, you referred to a female staff member as wifey and had to be told that that was inappropriate multiple times before you stopped. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/25/24, you called a female staff member a black fat multiple times when she asked you to hang up the house phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. 24, you told the Eddy Center program manager that you were going to smack out of her and started kicking the side of the door, which is the public safety risk. We were driving on Route 9 during that time. He also threatened saying that he was going to take our jobs and tell people that he beat us up when he was hitting it, or that we beat him up while he was hitting his head.
And we are about to watch the parole revocation journey of someone who some people on the internet might call an incel, or maybe he's just a Connecticut man going through the DOC. But what I will tell you is that his initial offense, he's locked up for starting a string of fires that went on and on and on. And since then, he has been in and out of special parole. So buckle up because we're about to dive into what parole and parole revocation looks like in the state of Connecticut. So with that, let's jump in.
You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, upon penalty of perjury?
Yes.
All right, thank you. First, I will read you your rights. Then I will review the parole violation charges that the state and your parole officer is bringing against you. Then I will review and identify exhibits filed on the record. The state is not present in today's proceedings. However, you will have an opportunity to present any relevant testimony and relevant documents. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose of the procedure before we begin?
Nope.
You have important rights to this hearing, which I will review with you. You have the right to be represented by an attorney at this hearing. You do have counsel here representing you today. You have the right to receive written notice of the charges of violation. Did you receive written notice?
Yes.
You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
All right. I will now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. On charge number 1, condition of obey all laws, obedience to the law, the charging officer reported that on 2/18/24, you threatened the staff member at Cohegan Halfway House and punched the walls of the program several times. In response to your behavior, the staff contacted Connecticut State Police and you continued these behaviors. Subsequently, you were charged with disorderly conduct, Connecticut General Statute 53A-182. On 2/20/2024, you were arraigned at GA 21, where a judge found probable cause and you were given a next court date of 4/2/24. On charge number 2, condition of additional conditions halfway house placement, the charging officer reported that on 2/18/24, you violated Cohegan Halfway House rules by threatening a staff member and punching the walls of the program several times. In response to your behavior, the staff contacted Connecticut State Police and you continued these behaviors. Subsequently, you were charged with disorderly conduct, statute 53A-182. For the record, the state submitted an addendum to Exhibit D, parole violation report. The addendum reflects that on 4/2/24, the subject, Mr. Fauquet, appeared in GA 21 for docket number A21N CR 24 0169860-S and was sentenced to 1 count disorderly conduct, receiving a 90-day execution suspended after and followed by 1 year probation. Ms. Jones, did you receive a notice of the parole violation and parole violation report and other documents?
Yes.
Thank you. 1 defense exhibit has been received. The defense has filed the following exhibit. Exhibit 1, list of parole accomplishments and future plans and parole reinstatement, which I have marked and dated 5/20/2024. Attorney Jones, do you need to continue the hearing to obtain any evidence, defense evidence?
No.
All All right, we have no witnesses. Are there any witnesses being present and going forth for today's hearing?
No.
Thank you. Attorney General, is now the defense's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted.
Thank you. And just for the record, Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Fauquet. In regards to the charges, charge 1, obedience to the law, you did indicate the addendum correctly. My client did receive that suspended sentence of 90 days, suspended a year probation. In regards to charge 2, I would just indicate that the violation for halfway house placement charges that my client was in violation of the halfway house rules by threatening a staff member. I would just note that my client was not charged with a threatening charge. He was charged with a disorderly conduct, and that conduct would correspond to the alleged punching of the wall. So I just make the record clear that he was not charged with a threatening in the second degree or threatening of any nature in regards to that alleged conduct. And that is all I have to say as to the charges. Thank you.
Thank you. Attorney Jones, would you like to make any closing statements before I announce my findings?
No, I'll just be heard in the second portion. Thank you.
Thank you. All right. I will now notify you of my findings. So on charge number 1, I find that you violated condition obey all laws, obedience to the law based on the preponderance of the evidence. Your conviction of disorderly conduct on 4/2/24 and the evidence provided in support of the charge, which includes Exhibit E, noted conditions of parole signed and dated 2/16/24, Exhibit D, parole violation report dated 2/26/24, Exhibit E, State of Connecticut investigation report number 24000065949, incident dated 2/18/24, Exhibit F, the Connection Cohegan House incident report dated 2/18/24, Exhibit J, Cohegan halfway house camera footage dated 2/18/24, and Exhibit K, State of Connecticut judicial branch printout dated 2/26/24. On charge number 2, I find that you violated condition additional conditions halfway house placement, and make a finding based on the preponderance of the evidence and the evidence presented in support of the alleged parole violation, as well as Exhibit B, D, Exhibit E, Exhibit F, Exhibit G, signed halfway house agreement, which was signed and dated on 2/16/24. Exhibit H, residential handbook signature page, an acknowledgement signed and dated on 2/16/24. Exhibit I, page 7 of the Cohegan half house residential handbook, which was notably listed in the PVR incorrectly as page 17. As I mark it, it is correctly listed. It is page 7. Exhibit J, Cohegan house, halfway house camera footage from 2/18/24. I would like to note for the record that I did also review the Exhibit 1 provided by the defense, which listed his plans for a halfway house placement, plans to apply for disability as a source of income. He's in a relationship and plans to marry sometime in the future and would eventually like to relocate out of the state of Connecticut. So this concludes the fact-finding portion of the hearing. Before I make a recommendation, you have the opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to determine what outcome I will recommend.
Thank you. My client is 30 years of age. He's single. He does not have any children. He is a high school graduate of Norwich Free Academy in Norwich. He does live with mental health as well as a serious medical condition. I won't go into detail as in regards to his medical condition for confidentiality purposes, but that information is contained within Defense Exhibit 1. So as you're aware, my client was released into the community on February 16th of 24, and he was remanded just 3 days later on February 19th of 24. He does tell me that he was having difficulty with a staff member at the halfway house, that he reported the issues and that the issues were not addressed. And unfortunately, his conduct led to his arrest and then remand. He's asking for an opportunity to be re-paroled so that he may demonstrate that he does have the ability to abide by parole conditions and can be successful in the community. Again, contained within the Defense Exhibit 1, it's noted that he previously was successful while on parole supervision. So I would ask that you take that into consideration as well. He's asking to be placed in a halfway house in the Willimantic area or whatever area is closest to that area. He does report that he has a treatment history in that area, working with CHR, where he was receiving medication as well, and attending relapse prevention. In addition, he reports volunteering at CCAR and a desire to return to that position as well. By way of financial support, due to his medical issue, he was receiving disability in the communities, and he's hopeful to resume that support once he's released back into the community. He's been in custody now for just over 3 months. Based on the court disposition, his underlying medical and mental health conditions that likely contributed to his conduct that led to his arrest and remand, we are respectfully requesting that he be re-paroled for the next board review date. Thank you.
Thank you. Do you have anything else that you wish to add before I make my recommendation?
No.
Thank you. All right. So I recommended your parole be revoked and you serve an approximate 6-month period of confinement as a sanction with a re-parole date of August 19th, 2024. I also recommend the following additional conditions: no consumption of alcoholic beverages, no contact with co-defendants, Matthew Markham, Jonathan Diaz, and Laura McDonald, halfway house placement, and behavioral management programming for anger management, along with mental health evaluation and treatment as deemed necessary. My findings and recommendations will be forwarded to the board. You should receive the official written decision from the board. The board may lessen the recommended sanction for your case. They may let my recommended sanction stand, or they may impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be held. Before the hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed the recommendation. During the supplemental hearing, you will have an opportunity to respond to those specific reasons while in front of the panel of the board. Do you have any questions before I conclude this hearing?
Yeah, I shouldn't have, so you're saying I'm gonna be in jail till August for misdemeanor?
That is correct.
Hey, fucking crazy, man. She pissed me. And so I get so this case is.
I'm not sure if you indicated, but what is the board review date?
It's going to be June 6th, 2024.
Thank you.
Do you have any additional questions?
I do not.
All right, this includes the revocation hearing. And I am now going off the record.
Thank you. Nicholas, if you have any additional questions, you can give me a call, okay?
All right,
All right, good luck.
fucking June, do this, fuck.
So what I wanted you to say.
I think you can take a couple of guesses of what it is that he said. Now, the way that it works is that they make a recommendation. The interviewer makes a recommendation to the parole board, and the parole board makes a decision on the decision date. And guess what they did? They said, 6 months. 6 months is too harsh of a penalty for this man. So we're going to shorten it up. And guess what happened? It's not even 6 months later. And guess who's back?
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Nicholas Paquette 391-725. Today is Tuesday, September 10th, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Nicholas Paquette 391-725.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney as well as Peel Bennett.
Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Paquette.
Good morning, Parole Officer Bethany Bennick with the Mental Health Unit.
This is a preliminary hearing, which has three purposes under Connecticut law. To determine if there is probable cause to believe you committed an act that violated the conditions of your parole. To determine if the act is sufficiently serious to warrant the revocation of your parole. And to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything that you say at this hearing can be used against you. This hearing is being recorded. The testimonies at today's hearing will be taken under oath. Mr. Paulette and P.O. Bennett, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. Thank you. First, I will read your rights. Then we will review the parole violation charges that the state your officer is bringing against you. Then I will review and identify exhibits filed for the record. The state will have an opportunity to address the issue of probable cause and the severity of the allegations. Once the state is finished, your attorney will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
Nope.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Nope.
You do? You understand these rights?
Yeah.
Okay. We now review the charge the state your officer is bringing against you and the information underlying each charge. Hey, officer?
Yep. Charge number 2, halfway house placement. On 7/1/24, you made a vulgar and inappropriate gesture
Excuse me,
towards
Bill,
a
starting
kid.
with charge one. Can we start charge one?
Sorry. Oh, I skipped a charge. Sorry.
Third charge, program participation.
Yep. Charge 1. On 8/9/24, you were negatively discharged from your mental health intensive outpatient group.
Charge 2, halfway house placement.
Okay. Charge 2. On 7/1/24, you made a vulgar and inappropriate gesture towards a case manager at the Eddy Center. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/16/24, you took the house phone into your room. This is a violation of the Eddy Center rules, which you acknowledged awareness of by signing the discipline report dated 7/16/24. On 7/18/24, you stole the house phone out of the case manager's office. You did not have permission to use the phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/18/24, you were caught vaping in your room. This is a violation.
It's not a good look for somebody who's trying to impress a parole board.
Sorry. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/18, you told your case manager to shut your mouth when he asked you to get off the phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/19, you were unaccountable in the community from 9 a.m. to 2:40 p.m. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/22/24, you referred to a female staff member as wifey and had to be told that that was inappropriate multiple times before you stopped. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/25/24, you called a female staff member a black fat.
You are trash.
Multiple times when she asked you to hang up the house phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/27/24, you called a female staff person a bitch and punched the wall several times. This is a violation of the Eddy Center rules that you signed on the resident handbook. On 7/31/24, you stole the cordless phone from the staff office. You did not have permission to use the phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/31/24, you told the Eddy Center program manager that you were going to smack the shit out of her. This is a violation of the rules that you signed in the Eddy Center handbook. On 8/6/24, you did not attend your mental health group. Subsequently, you were unaccounted for in the community for 3 hours. This is a violation of the Eddy Center rules that you signed in the resident handbook. Still the same charge. On 8/9/24, you stole the house phone and used it without permission. This is a violation of the Eddy Center, of the Eddy Center rules that you signed in the resident handbook. On 8/9/24, you were negatively discharged from your mental health group. On 8/13/24, you punched the wall in the Eddy Center, in the hallway at the Eddy Center, punched and broke a floor fan, and called the staff suckers. This is a violation of the Eddy Center rules that you signed in the resident handbook.
Charge 3, mental health evaluation and treatment deemed necessary.
Yep, charge 3 on 8/9/24, you were negatively discharged from your mental health intensive outpatient group that you were referred to by Middlesex Memorial Hospital on 7/31/24.
The state has followed the following exhibits.
You want me to read the evidence?
Yes.
I'm
Yes.
sorry. Okay. Exhibit A, remand to actual custody order. Exhibit B, signed conditions of parole. Exhibit C, signed notice of parole violation with rights. Exhibit D, parole violation report. Exhibit E, halfway house agreement. Exhibit F, Connecticut of Department Correction and Parole and Community Services residential discipline reports times 12. Exhibit G, Connecticut Department of Correction, Parole and Community Service Incident Reports times 4. Exhibit H, Connecticut Parole and Community Services Offender Misconduct Reports times 7. Exhibit I, Middlesex Hospital After Visit Summary Form with Recommendation Referral for Intensive Outpatient Mental Health Treatment. Exhibit J, Middlesex Health Discharge Letter, 4 pages. Exhibit K, the Connection Eddy Center Resident Handbook. Exhibit L, Signed Resident Handbook Acknowledgement Form. Exhibit M, Eddy Center video footage from 8/13/24, 2 videos which were uploaded to the DOC data case notes page. Exhibit N, audio recordings from P.O. Bennick State cell phone. There were 2 recordings uploaded. Exhibit O, photo from P.O. Bennick State cell phone. Exhibit P, Connecticut Board of Pardons and Parole Revocation Summaries times 3, 11 pages total. Exhibit Q, Willimantic Police Case Incident Report dated 10/1/23. Exhibit R, State of Connecticut Department of Public Safety Investigation Report dated 2/18/24.
Did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes.
At this time, the state will have opportunity to make a short statement and testify with respect to probable cause and the severity of the allegations.
Okay, sorry, I feel like I've been talking a lot already. As far as speaking on the offender's history and the reason for the violation, this is the 3rd time he has been violated for the same exact behaviors. I do note in the violation report that he is able to control these behaviors. He reacts certain ways to staff people and to myself after a remand has been executed. However, as soon as we arrive at Corrigan, the behaviors typically stop. The other issue is he poses a grave risk to public safety at the time of remand and at the time of Eddy Center when he is hitting things, calling people vulgar names, skipping groups, punching walls, breaking fans. I'd also like it noted for the record that during the transport, as included in my report, he continuously hit his head against the plexiglass of the cage and spit several times. He told this officer that he was going to kill himself. He said he was going to take our jobs, myself and P.O. Ludovico. He called me a several times. He stood up on the back of the seat, which is the photo, and started kicking the side of the door, which is the public safety risk. We were driving on Route 9 during that time. He also threatened, saying that he was going to take our jobs and tell people that he beat us up when he was hitting it, or that we beat him up while he was hitting his head. In my recommendation, I noted that he was violated for the same behaviors on October 2023 and February 2024. He was also put on probation for these behaviors on his 2nd case. So his probation officer is reviewing all of this evidence as well. I recommended 6-month sanction the last time, the 2nd arrest. It was agreed upon with the hearing examiner. However, the board changed the sanction at the final hearing to 4 months with this particular violation because it is the 3rd time I'm recommending 1 year. Thank you.
It is now the defense opportunity to respond, to make a short statement and testify with respect to probable cause and the severity of the allegations.
Thank you. In regards to charge 1, addressing charge 1 and charge 3 as they are duplicative, I would just note that Exhibit J indicates that my client attended 2 appointments, but then missed 3 consecutive appointments and was discharged. I would also just note that from the date of referral, which was July 31st of 24, to the date of discharge, which was August 9th of 24, that's a very short period of time, a week and a half. I think the evidence establishes that during that period of time, my client was clearly having a difficult time, and he is being supervised by the mental health unit. So I would just note that as well, too, in respect to his difficulties. In regards to charge 2 under halfway house placement, in regards to this July 1st of 24 incident, Exhibit F indicates that the behavior was dealt with by way of a graduated intervention and sanction. In regards to July 16th of 24, Exhibit F, page 2, this conduct was dealt with by way of a graduated intervention and sanction. July 18th, 24, Exhibit F, page 3, that indicates the conduct was addressed by way of a graduated intervention and sanction. July 18th, 24, Exhibit F, page 4, indicates the same. The second portion of July 18th, Exhibit F, page 5, indicates that conduct was addressed by way of a graduated intervention and sanction. July 19th of 24, we would submit there's insufficient evidence to support this portion of the charge as Exhibit G, which is page 1, indicates that staff was unable to confirm with the root center that the client was present at any point. And so I would just point that out. If they were unable to confirm, then it's our position that the state has not met its burden. In regards to the July 22nd, 24, Exhibit F, page 6, that conduct was dealt with by way of graduated interventions and sanctions. In regards to July 25th, Exhibit F, page 7, though the allegations, the alleged conduct was addressed by way of graduated interventions and sanctions. July 27th, 24, the client refused to sign the discipline report, which is Exhibit F, page 8. Therefore, we would submit there's insufficient evidence for finding a probable cause, as there's no admission as to that conduct. In regards to the July 31st, 24 incident, Exhibit F, page 9, indicates that my client was the subject of a disciplinary report that the PO, and the PO did not issue a graduated intervention and sanction in regards to that alleged conduct. In regards to the July 31st, second portion of that, Exhibit F, page 10, the client denies the allegations, refused to sign the disciplinary report, and the PO issued a graduated intervention and sanction to address the conduct. In regards to August 6th of 24, which is Exhibit F, page 11, my client denied and refused to sign. It does not indicate that a graduated intervention and sanction was addressed. In regards to August 9th of 24, Exhibit F, page 12, my client denied the conduct, refused to sign, and there was no graduated intervention and sanction listed. August 9th of 24, the second portion, that indicates that he was actually no comment as to that portion. August 13th, Exhibit G, indicates that the state police were called and addressed the situation and did not feel as though there was enough evidence to charge my client with any crime. And I already addressed charge 3, so nothing further as to the charges.
On charge 1, program participation, I make a finding of probable cause based on state's exhibits B, D, F, I, and J.
Oh, should I talk again before you make findings? Because I had a couple points.
You have more, sorry about that, yes.
Okay, I was waiting. I didn't want to, if you were thinking or writing. Yeah, I do have a couple notes. As far as him not getting criminal charged, the preponderance of evidence for a violation is lower standard than a preponderance of evidence for a criminal charge. As far as when the staff was unable to confirm his route placement, that means that they did not confirm that he was there. He was not there. I went there myself to look for him as well, which was also noted in the misconduct and the PBR. As far as the graduated sanctions and him receiving misconducts for these behaviors, misconduct means that we're giving him sanctions and attempting to work with him. They are not a violation of his conditions. We're now violating him on those. He has not been charged with them. It's just a sanction. Thank you.
Counsel, anything further?
I would just address those comments in regards to seriousness at the appropriate time.
Officer, anything further before I announce my findings?
No, thank you.
And counsel, you're all set?
Yes.
So charge 1, as stated, a program participation, I make a finding of probable cause based on state's exhibits B, D, F, I, and J. On charge 2, halfway house placement, I make a no finding on the following parts: 2, 3, 10, 13, 14, and 15. I make a finding of probable cause on the rest of the parts on this charge based on state's exhibits B, D, E, F, G, H, and J. On charge 3, mental health evaluation and treatment deemed necessary, I make a finding of probable cause based on state's exhibits B, D, F, I, and J. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. At the revocation hearing, a hearing examiner will determine if you violated the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what, if any, sanctions should be imposed. Your revocation hearing will be scheduled within 60 business days from your return to custody. You will receive a hearing disposition, which will have a tentative hearing date listed, as all of the hearing dates are subject to change. This now concludes the preliminary hearing. Anything, counsel, do you want to explain? Do you have any questions, Mr. Paquette?
Nah, I just, like, I read that, it doesn't make sense that I'm getting jammed up. Because if I punch a metal fan.
Okay, so
Where-
Nicholas,
where
I'm just
the
gonna
marks?
advise you to not, she's already made her findings and she's finding that it's serious enough to hold you. So I would just advise you not to further comment and that we will save our comments for the revocation hearing, okay?
That's Ms. Jones.
Thank you.
All right, thank you.
Okay, and we're going to fast forward to this now official parole revocation hearing. So as you can see, they have the preliminary hearing, which, by the way, they also have in other states that we cover, like Louisiana, but they don't make those preliminary hearings available in public to us. We don't ever see those, but in Connecticut, we do. But in this preliminary hearing, they decide how many of the sanctions they're going to allow now the official hearing to be brought before them, right? You get it? So she rolled out, I wasn't keeping track, but she rolled out a lot of them. And we see this happen all the time. And often it's on technicalities. Now, keep in mind, this entire process, in my opinion, is drafted in a way to keep the inmate from getting revoked. In my opinion, it's written with the inmate in mind, not with the DOC in mind, or public safety, I should say, in mind. It's the criminal in mind, because everything is stacked in their favor. You have a attorney appointed by the state to represent the inmate, whose only job is to represent the state appointed clients, and they are posed up against a probation officer whose job it is, as you hear, to transport criminals. They wear a bulletproof vest, they carry a gun, they are probably underpaid, overworked, underappreciated, and they don't have a law degree. And if they don't even show up, which sometimes they don't for these preliminary hearings, you simply get offenses taken away. Maybe a date is wrong, maybe an exhibit is not signed, and then it whittles down to what we have happen next. Now, this part, there's going to be a little bit of a twist to this, so let's just jump in.
Hello.
Hi, so I just wanted to let you know, I just got some information from my investigator that you're gonna be brought into court next week to be served with a violation of probation warrant.
I did yesterday. I went to court yesterday.
You went yesterday?
Yeah. And we
Okay,
supposed to have a legal call yesterday. They hit me up on 4 o'clock in the morning.
okay, so listen, I have a duty to not jeopardize your case in court by going forward with this hearing. It's my understanding that the conduct in the warrant is the same conduct that is alleged here. And because of that, I would not be comfortable going forward with your hearing until I speak with your attorney in court. So I would like to request a continuance, but obviously that's ultimately your decision. But you should.
I would told my attorney I want this squad because it don't make no sense that I'm
Okay,
wasting
but
my time in
listen,
jail.
please don't listen, Nicholas. Stay focused. Don't talk about the facts of the case. I'm just procedurally talking to you about how to go forward here. And I'm telling you that as an officer of the court, I don't want to jeopardize your court case. So that would be my request. So are you in agreement with that request?
Not really, but all right, we could do
No,
that.
so, no. It's yes or it's no. So are you in agreement with that request? I want you to understand fully what I'm saying to you.
Yes,
Okay. Okay, so you want to go on the record and I'll just make a record and then,
Did I miss
I'm
something?
I'm going to go on record and we'll, yeah, we're gonna go on record. Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons Paroles. This is a revocation hearing concerning Nicholas Walquette, 391-725. Today is Friday, October 25th, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Nicholas Boquet, 391-725.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is P.O. Bennett, as well as your attorney.
hi, Attorney Sonia Jones, Public Defender's Office Parole Revocation Unit on behalf of Mr. Falquet. And if I may, I was under the belief that my client was being brought into court next week to be served with a violation of probation warrant. He just informed me that he was brought into court yesterday and was served with a violation of probation warrant. With that being said, it was my understanding that the warrant is based on the same conduct that is alleged here in this violation of parole report. And so as his counsel here, I have a duty to him and to his counsel in court to not go forward with this hearing until I talk to that attorney to find out kind of what's going to transpire there. I don't want to jeopardize his defense in that case by going forward with this hearing. So at this point, it's my request for a continuance. And if I can just ask Mr. Falquet, because I obviously don't know this, what was the continuance date they gave you in court?
December 10th.
So I
Okay,
also did not know that that happened, and I would have to also do an addendum. But I would assume it's based off the same behaviors.
That's my understanding
Yeah.
from my investigator who had looked into it when I suspected that there was an issue, was that it's the same conduct that is alleged here. But obviously we don't have a copy of that warrant right now. We don't know that for certain. So I would like an opportunity to have that, and I'm sure you do as well. I don't know how
I would do the
realistic.
addendum, and then I'll get a copy of the warrant from the probation officer, and I can attach that to my evidence too, so the board would have it as well.
Okay, so I mean, again, with that continuance date being so far away, I don't know what you're comfortable with in terms of a continuance, but he just indicated December 10th, so I leave it to your discretion.
I just want to confirm, Mr. Falquette, you're in agreement with continuing today.
Yep.
Okay.
You
I'm
want
gonna
me
take
to
a
look
break.
up the court date?
He just said it's December 10th. Do you want to double
I
check
could
it? I mean,
verify it.
I can look it up too.
Okay,
Yeah.
while you guys do that, I'm gonna take a quick recess in terms of the next available date, considering this continuance together.
Copy.
Fucking judge.
Nick, you're not helping yourself. Don't talk.
You are trash.
It is December 10th.
Okay, you found it. You were
Yeah,
quicker than me.
It's December 10th. It's GA 21,
Yep.
which is Norwich.
Why would it would go back to Norwich, to the original court that sentenced him to
Yes,
probation?
yes,
Okay.
Yes, yep.
Nick, do you already have a public defender in Norwich?
Mhm.
Did you apply for a public defender?
Yep.
Okay.
I will note, Nick, that the judicial case inquiry does not indicate that you're represented right now. But I will contact their office to make sure that somebody is appointed to represent you if they haven't been already, okay?
All right.
Okay, so my next available date, based off of the continuance of the probation violation, is December 17th. That's my next available date for December.
That would be acceptable to me.
Based off of the request to
Yes.
continue December 17th. P.O. Bennett, are you also in agreement with that date? Okay,
Yeah, that's fine.
okay.
And certainly if I get the information, I will forward it to you in regards to, the warrant. If I
Yeah,
get it before you get it.
Yep, when we, I just emailed the probation officer, so as soon as I have that, I will let you guys know, and I'll just upload it to case notes and add it to the evidence. I
Okay.
have to find out too if it's talk to my supervisor about whether or not to change and recharge with a criminal or do an addendum. I haven't done this for a little while, so we'll have to figure out the correct way for my supervisor.
All right,
But
thank
I will
you.
certainly add the warrant to the evidence.
Thank you.
Thank you. So,
Yep.
the continuance is granted, and the next hearing, the revocation hearing date is scheduled for December 17th, 2024.
Okay, thank you.
Thank you.
Nicholas, I'll be back in touch with you, okay, so we can discuss it, okay?
Yeah.
All right, thank you.
Thank you.
Thank you.
All right, so they asked for a continuance because he was called in on a probation violation. And if you're wondering, wait, what's it mean probation violation? He's on special parole. How does he have a probation violation? It's because I got to point out that he has 2 additional convictions since being released on special parole. So one of those convictions that occurred, they said, we are going to let you out just with probation, as in, don't worry about it. You're not going to get more prison time, and you're also not going to get revoked. You're going to get probation. And he violated that probation. So even before they can get him on this revocation charge, they pulled him in on the probation related to a different felony. You guys get that? It's nuts. You see, because his original offense for lighting stuff on fire, which killed someone's dog and bird and almost killed them, happened in 2012. Then what happened, that was the arson, first degree. Then what happens is he, let me pull this up. Hold on one second. Okay, here it is. Then he has, he's sentenced on November 15, 2023 for breach of peace, second degree. And he's also sentenced on 2/18/2024 to disorderly conduct, which I think was what they were talking about here. Now, I've been going back and forth with Sir Richard on this because I was confused. Like, how is it possible that he's picking up new felonies and they're not, revoking a special parole? And he writes back, this is how succinctly, Sir Richard just writes back, what's not to understand? One case, the judge said unconditionally discharged, meaning you don't have to do anything. And the other case was a 90-day suspended sentence with 1 year parole. It's Connecticut telling really the world that they don't care, they don't want to revoke them because they want to be able to tell the world that they have the highest success rate in the DOC, that their approach to incarceration, their progressive approach is working. So you can't, they don't want to revoke people. So he gets new charges. I guess they're ultimately not, they didn't adjudicate them as felonies, they adjudicate them as misdemeanors. But in the state of Louisiana, you would simply get revoked for criminal activity. Here, you can get new convictions with sentences that it doesn't make sense. Because again, remember, special parole, the whole idea of special parole is, look, you're going to get a sentence, and then there's a parole attached to it, which is even a little bit different than normal parole. And that if you mess up, you're going to come right back to prison. But you don't come right back to prison. You mess up, and then the judge actually said in one of his cases, you get a suspended sentence with 1 year parole. So now he is serving parole, special parole, and probation all concurrent with each other. And that's the gimmick here. That's the joke. Do you guys get it? I hope I'm clearly explaining it. And maybe the whole idea of what they do in Connecticut is so that it is complex. It doesn't make sense. We don't understand it. But it's laughing in the face of the taxpayer. It's laughing in the face of it's skewing numbers, data, metrics, they would call his parole successful. They would call what he is going through on the piece of paper as successful because he is still out parole. And as you can see, someone who is just a drain on society, who this is the question. The Trump administration wants to bring back the mental institution. This is not a political statement. You had like 40, 50 years ago where they took them out of the US, and now they're in the question. I don't know, would he qualify that? Probably not. As you can see, he is all there. He knew that it was in his best interest to stay this hearing. He understood that. He knows what's going on. He's just, and as the probation officer mentioned earlier, which I thought was quite an interesting point, she said, hey, he behaves in prison. He doesn't behave in the halfway house. And he behaves in prison. And that's an interesting point too, isn't it? He's not getting write-ups while locked up. Got to take that in. So anyways, let's go and see what happens.
Good morning.
Morning,
Good
Theo
morning.
Bennett.
Good morning.
Ugh.
My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Nicholas Paquette, 391725. Today is Tuesday, December 17, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Nicholas Paquette, 391725.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Paquette.
As well as your parole officer, Theo Bennett.
Good morning, Parole Officer Bethany Bennett from the Mental Health Unit.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to uphold the sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Paquette and Theo Bennett, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officers bring against you. Then I will review and identify exhibits filed for the record. The state, as well as your attorney, will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, both the state and your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin? Thank you. You have important rights to this hearing, which I now will review with you. You have a right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to call. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges of the state your parole officers bringing against you and the information underlying each charge. Starting with charge 1, program participation.
On 8/9/24, you were negatively discharged from your mental health intensive outpatient group.
Charge 2, halfway house placement.
Okay, on 7/1/24, you made a vulgar and inappropriate gesture toward a case manager at the Eddy Center. This is in violation of the Eddy Center rules that you signed in the resident handbook. On 7/16/24, you took the house phone into your room. This is a violation of the Eddy Center rules, which you acknowledged awareness of by signing the disciplinary report dated 7/16/24. On 7/18/24, you stole the house phone out of the case manager's office. You did not have permission to use the phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/18/24, you were caught vaping in your room. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/18/24, you told a case manager to shut your mouth when he asked you to get off the phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/19/24, you were unaccountable in the community from 9 a.m. to 2:40 p.m. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/22/24, you referred to a female staff member as wifey and had to be told that that was inappropriate multiple times before you stopped. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/25/24, you called a female staff member a black fat bitch multiple times when she asked you to hang up the house phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/27/24, you called a female staff person a bitch and punched the wall several times. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/31/24, you stole the cordless phone from the staff office. You did not have permission to use the phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/31/24, you told the Eddy Center program manager that you were going to smack the shit out of her. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 8/6/24, you did not attend your mental health group. Subsequently, you were unaccounted for in the community for 3 hours. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 8/9/24, you stole the house phone and used it without permission. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 8/9/24, you were negatively discharged from your mental health group. On 8/13/24, you punched the wall in the Eddy Center. Oh my goodness, sorry, I'm getting confused. On 8/13/24, you punched the wall in the hallway of the Eddy Center and broke a floor fan and called the staff cocksuckers. This is a violation of the Eddy Center rules that you signed in the resident handbook.
And charge 3, mental health evaluation and treatment deemed necessary.
Yep, on 8/9/24, you were negatively discharged from your mental health intensive outpatient group that you were referred to by Middlesex Memorial Hospital on 7/31/24.
The state's exhibits were marked and identified at the preliminary hearing held on September 10th, 2024. Council, did you receive the notice of parole violation report, and the other documents that were marked for identification at the preliminary hearing?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Defense has also filed Exhibit 2, offender work performance and program evaluation form, and Exhibit 3, judicial just screenshots of case docket ending in 860. Today we have no witnesses, and at this time the state will have an opportunity to present evidence and speak to any of the evidence submitted.
I think I only have Exhibit 1. Hold on, I'm sorry. No, I have them all. I'm sorry about that. I mean, as far as the charges, they speak for themselves. He has very inappropriate and immature behavior towards staff. When they say no to him, he does the same thing to me. During the transport, I had noted in the parole violation report that he kicked the cage several times, banged his head, and was very distracting, screaming and yelling, which really poses a threat to the public as well as himself. He was bleeding by the time he got to Corrigan. But in the recommendation, I think I just asked for, I asked for a 1-year sanction because he received a 4-month sanction for his violation in October 2023, as well as a 4-month sanction for his violation in 2024. As far as the violation in 2024, the hearing examiner actually did give him a 6-month sanction, but when the board reviewed it, they saw that he was only at the halfway house for a week and then remanded. He was only at the halfway house for a week at that point in time because he was arrested for the same behaviors. That's all I have.
Council?
Thank you. My comments are essentially the same as they were during the preliminary hearing. I can go through them again. However, in regards to charge 2 under halfway house placement, just addressing the paragraph beginning in July 1st, Exhibit F indicates this behavior was dealt with by way of graduated interventions and sanctions. In regards to 7/16, again, Exhibit F, page 2, this conduct was dealt with by way of graduated interventions and sanctions. July 18th of 24, Exhibit F, page 3, that indicates the conduct was addressed by way of graduated interventions and sanctions. Exhibit for 7/18, the second part of that, again, page 4 of Exhibit F indicates the conduct was addressed. 7/18, part 3 of 7/18 indicates that the conduct was addressed as well. 719, we would submit there's insufficient evidence to support this portion of the charge, as Exhibit G, page 1, indicated that staff was unable to confirm with the root program the client was present that the client was present at any point. If they were unable to confirm that, then it's our position that the state has not met its burden. In regards to 722, Exhibit F, page 6, the conduct was addressed by way of graduated interventions and sanctions. 725, Exhibit F, page 7, the conduct was dealt with by way of graduated interventions and sanctions. 727, I would just note that my client refused to sign the disciplinary report. That's Exhibit F, page 8. 731 is Exhibit F, page 9. It says that the client was the subject of a disciplinary report. The PO did not issue a graduated intervention or sanction. 731, the second portion of that, Exhibit F, page 10, my client denies the allegations, refused to sign the disciplinary report, and that the PO did issue graduated interventions and sanctions. In regards to August 6th of 24, Exhibit F, page 11, my client denies that conduct, refused to sign, and it does indicate graduated interventions and sanctions were listed. In regards to August 9th, Exhibit F, page 12, the client denied the conduct, refused to sign. It does not indicate that any graduated interventions and sanctions were listed. In regards to the August 13th, Exhibit G, the state police called to assess the situation, did not feel as though there was enough evidence to charge my client with any crime, just pointing that out. In regards to charge 3 under mental health treatment, Exhibit J, my client attended 2 appointments, but then it says it missed 3 consecutive appointments and was discharged. I would just note that from the date of referral, which was on 7/31 of 24, to the date of discharge, August 9th of 24, a very short period of time. I think the evidence establishes that my client was having a difficult time, and I would just point out that that's a very short period of time for which for him to comply with that treatment. Nothing further as to the charges.
Thank you. Bennett, anything further before I announce my findings?
Sure. I think we had the same discussion last time, and it was the same findings. The amount of interventions and sanctions that he received, I think, show more in our favor that we really did try very hard to work with him, and he did not amend any of those behaviors or change those. As far as the mental health treatment, he was referred, and it was supposed to be a PHP, so he was supposed to go all 5 days in that week. That's all I have.
Thank you. Counsel?
Just that it's a very short period of time that we're dealing with here. That's all I would point out.
Bennett, anything else before I announce my findings? Okay. And counsel, nothing further?
Nope.
Okay, thank you. Regarding charge 1, program participation, I make a finding based on 6 exhibits B, D, F, I, and J. On charge 2, halfway house placement, a no finding was made on parts 2, 3, 10, 13, 14, and 15 at the preliminary hearing held on September 10th. Being that there was no further information provided today by the state, those no findings will remain for today's hearing. However, I do make a finding on the rest of the parts listed in this charge based on state's exhibits B, D, E, F, G, H, and J. On charge 3, mental health evaluation and treatment deemed necessary, I make a finding based on state's exhibits B, D, F, I, and J. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney, as well as the state, will have an opportunity to speak to your background and history. Bennett?
I think I already included the background and history that I would consider including before when I talked about the amount of violations and how quickly they happen. That's all I have.
Thank you. Counsel?
Thank you. My client is 31 years of age. He's single. He has no children, though he has a 7-year-old stepchild. He's a high school graduate of Norwich Free Academy. He has no additional education and supports himself in the community by way of receiving disability for a medical condition that he has. He receives his primary support from his fiance, his family, his siblings, and his mother and father. He lives with both mental health as well as substance abuse issues. He was additionally diagnosed with a serious medical condition. That information is contained within Defense Exhibit 1. He was in the community, I believe, for approximately 2.5 months. I apologize. As you're aware, he was re-paroled back into the community on June 18th, I believe. He explained to me that he was having a difficult time with staff at the halfway house. He was feeling threatened. He indicated he reported the issues to the Halfway House staff supervisors. However, he felt as though the issues were not being addressed properly. I would point out that he was that regarding the incidents noted in the charges, the state police responded, 3 troopers, in fact, and they did not feel as though any laws were broken, and my client was not arrested as a result of that. On August 1st of 24, my client did begin mental health treatment by way of intensive outpatient treatment at Middlesex Health Bay at Pele Center for Mental Health Services in Middletown. He completed 2 sessions, and though Mr. Fauquet is supported by disability, he has actively searched for work. Our office received documentation from Reach that confirmed that my client was applying for jobs weekly, that he had interviews at Applebee's, McDonald's, Cumberland Farms, Dunkin' Donuts. He is asking for the opportunity to be re-paroled back into the community so that he can demonstrate that he does have the ability to abide by parole conditions and be successful in the community. In addition, he also reports volunteering at CCAR and a desire to return to that position. While he's been incarcerated at this point, he's been in custody now for approximately 4 months. He did complete the Voices program, and I would just note that within that completion, it does indicate his attendance and initiative, productivity, attitude, and overall were recorded as excellent. The comments were that Mr. Fauquet always participates in group discussions. He attended every class with a positive attitude. He had great interactions with his peers. He identified coping mechanisms that he'll utilize whenever he feels stressed. Overall, he's on the right path for making positive changes in his life. So I think that that's important to note, that is something that he has accomplished during this time period that he's been incarcerated. Again, by way of employment, he hopes to return to the community and continue to receive disability, though he does hope to have a part-time job, whatever's permitted through his disability. He's been in custody now for approximately 4 months. And I would just note, based on the technical nature of the violation, as well as his underlying medical conditions that likely contributed to his conduct that led to this violation and ultimate remand, we are respectfully requesting that he be re-paroled at the next date. And I would note that my client was served with a violation of probation warrant during the time period that he's been in custody. I believe his parole officer is aware of that as well. We did submit a request for addendum. However, that was not complied with for whatever reason. I think we probably all can make an assumption on that. I did submit that disposition as evidence here, and I'm asking that the hearing examiner take into consideration that he received a 30-day sentence when issuing the sanction, so that when Mr. Fauquet is eligible to be re-paroled, that he's not re-violated again on a matter that we all were aware of during this hearing. So he was violated on his probation. The violation was based solely on the conduct that's listed in this parole violation report. And based on that, he received a 30-day sentence. And I'm asking that that be taken into consideration. It's been filed as evidence. Everyone here is aware of it. So I am asking that it be taken into consideration here. Again, we're asking based on the situation, the totality of the circumstances here, that he be given an opportunity to re-parole at the next date. Thank you.
Thank you. Phil Bennett, anything further?
No, I did not charge him with the criminal violation though, so I don't think we're really going to consider it in this hearing.
Thank you.
I understand that, but it's a violation of probation that was served on him during the pendency of this violation. I think we were all aware of it. We continued the hearing, in fact, so that we could see the disposition of that violation of probation. I did make a request for an addendum. It could have been added. We are all aware that he received a 30-day sentence. I understand that there are supervisors who do not wish that be included so that they can re-violate him. I don't think that's a proper procedure, but I understand that it's a procedure that's in place. I submitted the disposition as evidence. I'm asking that it be considered. I don't see that it would be necessary for Mr. Fauquet to be given a re-parole date only to be re-violated for conduct that we're all aware of right now. Thank you.
Okay, Phil Bennett? Okay, and counsel?
Nothing further. Thank you.
So before I make my recommendation, I would like to make all parties aware that while I'm aware of Mr. Fauquet's violation of probation, 30-day conviction. While I am aware of the conviction, I am not aware of the details or the specific information regarding the actual violation of probation. With that said, if the violation of probation is for the same exact charges that he's being charged with today, my sanction would remain the same. However, if there's additional information in that violation of probation that could potentially merit a longer sanction depending on what that information is, if it's not already included in this, what's he's not already being charged for. So I was going to make that clear. So
So if you would like, I would request a continuance to get a copy of the violation of probation warrant to file it so that we are not back in the same situation where he's being re-violated for the same conduct, if that would be appropriate.
He's absolutely going to be re-violated on the same conduct because it warranted a criminal charge and an entirely separate warrant, which was signed off by a judge and he was found guilty of. Two separate things. And
So
we're
then
absolutely going to do that.
It's not a criminal charge, it's a civil, it's a preponderance of the evidence standard, so
It's going to be
I
a
would
criminal
disagree with you.
violation.
And he wasn't found guilty, it was an admission.
So with that said, I'm going to take it. So before I take a recess, Attorney Jones, are you going to request a continuance? So
Well, if what you're.
I didn't charge him with that. Again, I have every right to charge him criminally. I did not charge
So
him
can
with
I
that.
just-
This
okay,
is a
can I just
technical violation.
So for the record, if the addendum included the disposition on.
I didn't do an
violation-
addendum. There's no
Okay.
addendum.
Okay, that's not what I'm saying. I'm saying hypothetically, if the addendum included the disposition on the violation of probation, I believe that the hearing examiner would be considering that. So noting that I requested an addendum to include the violation of probation, which you did not provide, which I understand that you didn't provide it. Okay. I filed it as evidence. So if you can file it as part of the addendum and it can be considered, it should be considered when I file it as part of the evidence as well. That is my
Very
position.
fair, but the new charge and the new violation will include a new warrant as evidence.
All right, so I'm going to take a recess. I'm going to speak to my supervisor about how to proceed moving forward.
Thank you.
Okay.
Yeah, we have my 30 days though. It makes sense to me. Yeah, they were sentenced me. Yo, since I prepared my crown. But anyway, I would take my 30 days. I got my shit right here. Oh, perfect. Actually, anyway.
Nicholas, please refrain from speaking right now, okay? Thank you.
Thank you for waiting. We are now back on record. So after, P.O. Bennett, are you there?
Sorry, I'm here.
After consulting with my legal counsel, P.O. Bennett had made it very clear that the state is not going to be filing an addendum for this charge. Therefore, we would not be moving forward with a continuance. And I'm going to make my sanctioning at this time. I recommend revoke and reparole on April 14th, 2025, which is an approximate 8-month sanction with the following conditions. No consumption of alcohol, anger management, no contact with co-defendants Matthew Markham, Jonathan Ortiz, and Laura McDonald, halfway house placement and mental health evaluation. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on January 2nd, 2025. So on that day, January 2nd, 2025, the board is going to take a look at your case, and they're going to either, they can lessen my sanction, let my sanction stand, or they can impose a sanction longer than what I have recommended. And if they choose to do a sanction longer than what I have recommended, then a supplemental hearing will be held at that time, and they will provide you with written decision as to why they would want to justify additional confinement. Okay, any questions?
I have a comment. Just during the recess, I was able to take a look at the violation of probation warrant, and the conduct alleged in the violation of probation warrant is the same exact conduct alleged here. It's charge 1, as well as the fact that the violation of the parole conditions in general, just so that's clear for the record.
Thank you. So this does conclude the revocation hearing.
Thank you.
Thank you.
Nicholas, if you have any questions, you can give me a call, okay?
Yeah. Okay.
All right, and when it's all said and done, she recommended 8 months. It's my understanding the parole board agreed to that, and now he is out. He is out. He's with his PO at the time of this recording, July 31st, 2025. He has not been revoked yet again, but he is on special parole until March 2026. So if I was a betting man, I would bet that we will see him again. I just don't think he has it in him to stay out. As you can see, it's like it's really, it's just disgusting. It really is. I don't think it's anything short of just disgusting. And keep in mind, we'll go over what his original crime was, but the whole insanity of this case, as you can see, is that he's out on special parole. He catches new, I guess, a new charges, gets convicted. You know how funny it was with his attorney's like, he wasn't found guilty of it, he admitted guilt. Oh wow. I mean, these attorneys, they really go to bat for their client. You got to give that to Connecticut. I think you do. It's like they just want to win, which is good. These might be public defenders, they're defending their clients that are just like, whoa, but they go to bat. I mean, they fight it, Mr. Megaletti, whatever. And
everybody has a terrible time trying to pronounce his name. How do you spell that again? I'm like family and Getty. Family and Getty.
Helpful. Family.
Right.
Absolutely. Go ahead, attorney.
And
they seem to go, they really go down hard for their clients, and it's the system that is really designed, again, to protect. And I feel bad for these probation officers, these parole officers. They're carrying a gun, they're wearing a bulletproof vest, they're dealing with these nut jobs, they're underpaid, they're overworked, and then they have to go up in front of an attorney who's an attorney who went to law school as an attorney, and it's like the cards are stacked in the favor of the inmate. And the inmate is sitting there, eating his hands and whatnot, and he picks up, he gets a new sentence of of probation, which he gets. You saw that probation got him faster than the parole, right? The probation that picked him up, not the parole. And so he gets probation. So he's a probation officer, I guess a parole officer. Maybe it's the same person. Who knows? He's serving parole for another charge. The judge sentenced him to parole, 1 year suspended sentence with parole. How do you get a 1 year suspended sentence when you have special parole? You violate your special parole, and the judge says, in my wisdom, I'm going to give you a 1 year suspended sentence. And then another time, and the judge says, I'm going to let you off, but probation. It's like, what? You're already on supervision. How does that make sense? Judge, sit across the table from me and explain to me, as if I am a 5-year-old, how it makes sense as a punishment to give someone parole when they're on special parole. How do you give probation as a punishment when you're already on special parole? Judge, I'm 5 years old. Tell me, I'm waiting. And I'll tell you why. And It's because there is an agenda. It is about how can we tell our constituents and the world or America that our progressive approach to the Department of Corrections is better than others. And this is important. And I don't know which system's better, okay? I don't. We watch both. We see Louisiana, we see Connecticut. In some sense, it seems Louisiana, it's stacked against the inmate. The inmate can be involved in criminal activity. Who knows whether it was there's got to be a percentage of times that the inmate, we've seen enough revocation hearings where the inmate maybe really shouldn't have gotten revoked, but they're not able to articulate the situation. They don't have an attorney, they're representing them. And it's like, they get revoked. And it's in no one's best interest, not the taxpayer, not. And in Connecticut, it's the exact opposite. So you have two extremes. And then you have Connecticut or people will look at Louisiana and say, wow, your incarceration rates are sky high. This is crazy. You guys just like locking people up. And Connecticut will say, our incarceration rates are some of the lowest in the nation because we give them CDL license training and we give them halfway houses and we give all these great programs and we give special parole, this unique configuration of parole, and we do all this. And look, our incarceration rates are lower. But really, what it is that it's skewing the data. We see, you know how many revocations we cover every week? I hardly show them, and the reason I don't is because they're harder for me to put together. They're harder. They're confusing these different parts. You have the initial process, the second process, and a lot of times there's no context of their crimes, so it's more complex. But there are more revocation hearings than parole hearings. They're all the time, and we see the same people come back over and over and over again. But what they documented on their ledger, in their stats, in their data, in their storytelling are not revocations. They are penalties. They are sanctions, is the right word. I will give you a 6-month sanction. And then Connecticut gets to go and say, we are doing it right, but you're not. And we see that. And that's part of what, it's really interesting. And look, you can, this is my perspective, my view of it. Maybe you have a different opinion. I don't know. I actually don't know the answer of what the right thing is. I think it's quite interesting to say to give someone an attorney. I actually do. I think it's okay. But the problem is, the problem, and again, also the process with Connecticut, it's done like a court proceeding. The interviewer is like, well, remember how many charges he had to begin with? And she wiped off like half off the list because this wasn't signed right, or this wasn't dated, or this doesn't have it. Think about it, from the beginning of the process until the end, it is stacked to protect the defendant. Not, you know what? I'm not going to go into what I think could work or what I think is best. I'll just lay out my. I have to think about it. I really do. But it is kind of crazy. Oh man. So his initial crime, 4 charged with arson. This was 2012. Look at these 4. They're so cute. What a great little group. Kind of look related, though. Nora police have arrested a group of 4 in connection with the 2 intentionally setting fires, including a blaze in Springs Oak, that sparked fires at adjoining homes and temporarily displaced more than 24 people. Good job, state of Connecticut, causing $500,000 in damage. One of those charged was 45-year-old Laura McDonald, was on probation at the time. Oh, no kidding. She was on probation at the time of her arrest for her part in setting a 2010 fire that destroyed the Century Cold Cape Hill Mill. We just had an arson case. We've covered a few of them. A lady arson person. McDonald, a client, Reliance House, who is under supervision, was assigned to Norwich Superior Court Wednesday. She was held, blah, blah, blah. It's unclear whether McDonald talked to police about the role in the fires, But the interview last month, she handed police a Bic lighter saying, "Here, take it from me. I'm in violation of my probation by having this with me." You know, it's bad when in terms of your probation that you can't even have a lighter. That doesn't, how are you supposed to? Along with McDonald, police have arrested Nick, that's our prince right here, Matthew and Jonathan Ortiz, whose brother is Roman Ortiz. Oh, okay. Police say that they took part in setting a fire on March 26th and March 29th. Police said that the group broke in and doused areas of structure with gasoline. Wow, this isn't like just they douse it in gasoline. Their possible role in several other suspicious fires are under investigation. All four are charged with 2 counts, each first-degree arson, third-degree burglary, and first-degree criminal mischief. The motive for setting the fire is unclear. I wish I could explain it and get into their heads, the police sergeant said. It seems to be a thrill, or maybe it's boredom. I don't know. The 2 fires are among at least 7 that have plagued the city during the past year that are under investigation by an arson task force. These people are just horrible. You know, they need to be locked up. Newark Police has dedicated 2 experienced arson investigators. The work of the same team 2 years ago led to 10 arrests in connection, released a dozen fires. The Oak Street fire, the most damaging, the vacant multifamily home, was fully engulfed in flames as firefighters arrived because of the intensity of rapidly spread adjoining buildings. 21 people are evacuated, and the fire personnel endangering lives of firefighters and residents. 2 city firefighters sustained injuries fighting the fire because of the extent of the damage. The cause was undetermined. 3 days after the Oak Street fire, firefighters responded to 11 straight, blah, 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 vacant building, blah, blah, blah. Along with Ortiz, police said that they developed other suspects through dozens of interviews. Nick, who police said admitted to his fire rules, more information, and witnesses later came forward, including a person who told police that he was involved, blah, 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 blah. And then what happens is they get their sentence and they get special parole for some of that sentence, and then you get this clown fare. And I got to again say thank you to Richard E., who brought these hearings to me and been asking me to do it for quite some time. Had it in the recon row highlighted, and I just kept pushing it off. It's like hard for me to wrap my mind around this stuff. And then he was answering questions as I was going through it, because I'm just like, how is this possible? How does this make sense? And he simply responds like succinctly in an email, like, Mandoo, it's like they do this because they don't want to revoke them. It's like, it's kind of clear. It's the agenda that they're pushing, data. You know, if they were an accountant, you might think that that it would be, you know, illegal accounting, because it's just crazy. But anyways, that's my opinion. What's yours? Leave me a comment, because it does help the channel reach 100,000 subs. We are so close, but it's like need your help to get us there. Really want to hit that 100,000 special mark. So with that, I'll let you go.
On 7/22/24, you referred to a female staff member as wifey and had to be told that that was inappropriate multiple times before you stopped. This is a violation of the Eddy Center rules that you signed in the resident handbook. On 7/25/24, you called a female staff member a black fat multiple times when she asked you to hang up the house phone. This is a violation of the Eddy Center rules that you signed in the resident handbook. 24, you told the Eddy Center program manager that you were going to smack out of her and started kicking the side of the door, which is the public safety risk. We were driving on Route 9 during that time. He also threatened, saying that he was going to take our jobs and tell people that he beat us up when he was hitting it, or that we beat him up while he was hitting his head.